His all topics are always insightful, precise, and concise. We always discuss as a lawyer and otherwise also. The cross-examination is an art. And today's topic is narrowed down in respect of the importance of cross-examination in sessions trials. We were slightly late, so I will not take much time in the introduction of Mr. Karunanithi. Otherwise, also he's a well-known face, pan world. Over to you, Mr. Karunanithi, and thanks for accepting our invite.
A very good evening to one and all present here and through YouTube. Very nice meeting once again through web. Today, the very important topic chosen by Beyond Law, cross-examination in a sessions case is the topic today. What is cross-examination? Why cross-examination in a criminal case is very important? Let us go through by reading the judgment of the Honorable Supreme Court and various high courts. Before going to the topic, let me take a few minutes regarding the cyclic of criminal cases. FIR is the first and foremost document. As soon as first information report is registered, or in some cases contraband is recovered, the seizure magazine, the investigation begins. From the first information report and the final report, the in between the A and Z, that is the FIR and the final report, as contemplated under 173 subclass 2 CRPC 1973, the process is nothing but collection of all evidences, that mean investigation as defined under section 2H of Code of Criminal Procedure 1973. Collection of all evidence is the very language used in section 2H of CRPC. So let me say whether all the materials collected during the investigation are evidence. If that be so, the statement of witnesses recorded under section 161 subclass 3 CRPC, can we take it as a evidence? Can it be marked? Whether confession of an accused recorded by the police officer, can we say it is an evidence? Can we mark the confession of an accused before the police officer? Definitely there will be these two questions in our mind. To my knowledge, yes, these two documents are no doubt evidence. Then my learner friends may ask, brother, how can we say how it could be classified as evidence? It is an evidence, no doubt, but for a very limited purpose. In order to take cognizance of offences by invoking section 190 of Code of Criminal Procedure, and for the very limited purpose to frame the charges, the learned judge can consider the statement of witnesses and the documents collected during the evidences, including the confession and a disclosure statement, as evidence for very limited purpose. But the law requires legal evidence for the purpose of convicting an accused. For the purpose of convicting an accused, the law requires legal evidence, both oral and documentary. No doubt, the criminal investigation begins as soon as FIR is registered. Everybody know well. And immediately, the investigating officer used to record a statement of witnesses in a cyclic FIR, statement of witnesses, arrest, and final report. Thereafter, cognizance of offences will be taken by the learned judge, and appearance of the accused. Copies of the document will be furnished to the accused free of cost. and framing of charges, then opening of case by the public prosecutor, and after the evidences are over, questioning of an accused under section 313 1B of CRPC, and thereafter advancing arguments by both the parties. Thereafter, the crucial part of the criminal trial is appreciation of evidence. Appreciation of evidence. So, when evidence of prosecution or defense is to be appreciated by the learned judge, it can be appreciated. The prosecution will march both oral and document evidence. Many documents can be placed before the learned judge. Many witnesses can be examined as a prosecution witnesses in order to prove the charges leveled against the accused. So, what is important in a criminal trial, the two in a sessions case, is cross-examination. It is a very, very valuable weapon at the hands of a learned defense counsel. No doubt, according to the Honorable Supreme Court of India, it is an acid test. Acid test. The prosecution is expected to prove the charges leveled against the accused beyond all reasonable doubt. The elementary and cardinal principle of law is that prosecution alone has to prove the charges, no doubt at all. But in some cases, there are presumptions are there. But where from we are getting the theory of benefit of doubt? Let me quote 4 judgments. The first judgment is Wilmington versus Director of Prosecutor. Wilmington versus Director of Prosecutor, 1935, AC page number 462. 1935, AC 462, Wilmington versus Director of Prosecutor. Second case law is Miller versus Minister of Pensions, 1947, volume 2, all English reporter, page number 372. 1947, volume 2, all English report, page number 372. The third one is AIR 1979 Supreme Court, AIR 1979 Supreme Court, page 387. K. Gopal Reddy versus State of Andhra Pradesh. K. Gopal Reddy versus State of Andhra Pradesh. According to the Honorable Supreme Court in the said case, throughout the web of the English criminal law, one golden principle and golden thread is always to be seen. That is, it is the duty of the prosecution to prove the guilt of the accused. And the earliest judgment, yet another judgment is AIR 1979 Supreme Court, AIR 1979 Supreme Court, page number 1567. 1567. Came Karan and others versus State of Uttar Pradesh and another. So, no doubt, heavy duty is on the prosecution to prove the charges leveled against the accused. Now we are very clear. It is for the prosecution to prove the charges. We can say no. It is for the prosecutor to prove the charges. So we can keep mum. No. In some cases, for example, the Protection of Children from Sexual Offences Act 2012 and the Prevention of Corruption Act, and in many cases, presumptions are there. Presumption. And Section 106 of Indian Evidence Act 1872. Section 106 of Evidence Act 1872. No doubt, there are presumption clauses in POSCO Act and PC Act. It does not mean that simply because the final report is there, some evidences are there, the prosecution can prove so easily. But it is only a rebuttable presumption. It is only a rebuttable presumption. Still, the fundamental principles has to be proved only by the prosecution. Since there are some presumption clauses are there, does not mean the burden of proof is shifted to the accused. The very great Tamil poet Thiruvalluvar, in his poetry, namely Thirukural, I want to quote two poetry. Epparul yar yar vai ketpinum அப்பொருள் மெய்ப்பொருள் காண்பது அறிவு. How to appreciate evidence. More than 1,000 years ago, in the state of Tamil Nadu, the great poet said, to discern the truth in everything, by whomsoever spoken is wisdom. It is needless to say that 100 criminals may escape from the clutches of law, but not a single innocent be punished. And yet another Tirukural I want to quote, கண்ணால் காண்பதும் பொய், காதால் கேட்பதும் பொய், தீர விசாரிப்பதே மெய். I want to underline தீர விசாரிப்பதே மெய். That is, whatever seen by you and whatever heard by you need not be truth. What is elicited through proper inquiry shall only be the truth. What is elicited through proper inquiry shall only be the truth. Only be the truth. So, in order to elicit the truth, the cross-examination is the very, very important tool at the hands of the learned defense counsel. The cross-examination, according to the Honorable Supreme Court of India in Kartar Singh versus State of Punjab, in Kartar Singh versus State of Punjab, full bench of the Honorable Supreme Court reported in 1994 SEC volume 3 page 569. It was authored by Honorable Mr. Justice S. Ratnavel Pandian. The cross-examination is the acid test. What for the cross-examination is made? In order to test the truthfulness of a witness, to destroy or to weaken the evidentiary value of a witness, to impeach the credit of a witness, the cross-examination is made. Fair trial, as everyone knows well, fair trial is guaranteed under Article 21 of the Constitution of India, and cross-examination is also part of Article 21 of the Constitution of India. As I said, the law requires in the Indian Evidence Act and Bharatiya Sakshaya Adhinayam speaks volume about legal evidence. What is the difference between the evidence and the legal evidence? Means the evidence so collected by the investigating officer is in the form of a statement of a witness, in the form of a confession, though they are inadmissible into evidence, though they are not to be marked as a prosecution document. How it can be used? Section 162 CRPC says, and the admissible portion of confession, the disclosure statement as per Section 27 of Indian Evidence Act. So there is a difference between the evidence and the legal evidence. In order to take cognizance, in order to frame the charges, in order to decide an application for disposal of property, those materials can be relied upon, and to decide a writ petition, no doubt, according to the Honorable Supreme Court, statement of witnesses can be taken into consideration. Even the confession of an accused before a police officer can be considered to decide a writ petition, but it is not a legal evidence to convict an accused. Recently, the Honorable Supreme Court, why I have chosen this topic, cross-examination of criminal case. Very recently, the Honorable Supreme Court of India, by setting aside the capital punishment, gave a direction that the judgment of the Honorable Supreme Court has to be forwarded to all the High Court, and all the Honorable High Courts were directed by the Honorable Apex Court to circulate the judgment to all the district court. The Honorable Supreme Court came down so heavily and recorded that there was a lack on the part of the learned counsel to contradict the witness. And the Honorable Supreme Court recorded that the learned counsel has no idea about how to contradict a witness. Right? This is a reported judgment in SEC criminal as well in live law, 2023 live law, page number 744. Munna Reddy versus State of Bihar. Munna Reddy versus State of Bihar. The capital punishment was set aside. The matter was again remanded back to the Honorable High Court for consideration. In para 41 of the judgment, the conduct of a witness, conduct of the learned counsel before the trial court, how to contradict a witness has been recorded, and duty of the learned counsel to contradict a witness and to how to cross-examine the witness has been earmarked in para 41 of the judgment. And very, very important judgment from the Honorable Madras High Court. A. Muthupandi versus Inspector of Police, Tirupur, all-woman police station. It's a case of 376. Accused was convicted under section 376 IPC. Paragraph 32, 33 and 34 are very relevant. The learned judge recorded that I want to read one paragraph. It is quite unfortunate that the learned trial court advocates are not developing their skills of cross-examination. Most of the questions which are put to the witnesses are irrelevant and illogical. There was an injury on the private part. There was a suggestion by the learned counsel. It was by a bite by ant. So the exhibit D1 was marked through a doctor. The very same doctor was examined as a prosecution witness number 6. So the learned judge came down so heavily by marking exhibit D1. The prosecution was strengthened. It is not a contradiction to evidence of PW6 who examined the victim first. PW6 in the Muthupandi case was a doctor. The very same one of the document was marked as a defense document number 1. So the attempt of learned counsel by marking a defense document, according to the learned judge, it is not a contradiction. It improves the case of the prosecution. And so, since the learned judge also recorded that the learned counsel, before ready for cross-examination, one must know the human anatomy. And in yet another case decided by the Honorable Supreme Court, Vijay Kumar versus State of Madhya Pradesh, very recent judgment, 2024 live law, page number 403. Vijay Kumar versus State of Madhya Pradesh, 2024 live law, Supreme Court, page number 403. The answer given by the accused while questioning under section 313 1B CRPC. In the answer, the accused stated that the victim in a 376 case, in that case, was a consenting party. So necessarily there must be a suggestion to the victim. There was no suggestion at all. So the Supreme Court came down heavily. The conduct of the counsel and the cross-examination was highly commented. Very, very latest judgment. So 2024 live law, Supreme Court, page 403. So these are all the judgments. And in one another judgment, the counsel who appeared before the trial court was highly appreciated by the Honorable Supreme Court. It's a case of rape and murder of children in Coimbatore district. No counsel appeared. A counsel from legal aid was appointed by the learned trial judge. Capital punishment awarded was by the learned trial judge, confirmed by the Honorable Madras High Court, and the same was confirmed by the Honorable Supreme Court. An application to review was placed before the Honorable Supreme Court. On that ground, there was no proper legal assistance to the accused. This is very, very important. In the review application, on one point, there was no proper legal assistance, so the conviction has to be quashed. According to the Honorable Supreme Court, we have in the very same word, we have gone through the cross-examination made by the learned counsel, who was appointed as a legal aid counsel by the learned trial judge. We came to know the length and breadth of the practice of the learned counsel. So the the cross-examination was appreciated by the Honorable Supreme Court in that case. So cross-examination as decided by the Honorable Supreme Court is an acid test. So before taking up a case, before going to cross-examine the witness, in a criminal cases, that too in a case of a murder, we have to go through the papers at least for 5 or 10 times. My humble request is to go through the original documents, such as FIR, statement of witnesses, and in some cases, alteration of FIR, the alteration of report will be there. Suppose a case has been registered under section 307 of Indian Penal Code, that is attempt to murder. And after some medical treatment, the case could have been altered into offense under section 302 of IPC. So according to the Honorable Supreme Court, not only the first information report, as well the alteration report ought to have been forwarded to the concerned judicial magistrate court without any delay. Since the FIR is found to be the earliest document, we can attack. First impression will be the best impression. If the prosecution cannot go against the FIR, we can say it is contradictory to earliest version. So the prosecution has to construct its building in the FIR. If FIR is collapsed, the entire construction on such an affair would definitely collapse. There are many judgments on the point. The first and foremost point to attack the FIR is, no doubt, first information report is not an encyclopedia. All the minute details need not be incorporated in the FIR, but the basic thing has to be mentioned in the FIR. If FIR is forwarded belatedly, that is a very good point to canvass before the learned trial judge to reject the FIR. What would be the reason for rejecting the FIR? Simply because there is a delay in forwarding the FIR to the concerned. Taking advantage of delay, the earliest information is suppressed. The innocent people have been included in the FIR. That is the sole ground for the delay. We have to suggest, no doubt, obviously, there is a delay. Why the cross-examination is necessary? Whether cross-examination is mandatory, if no cross-examination, whether the benefit of doubt arising out of delay in forwarding the FIR can be extended to the accused or not. This is a very bigger question. No doubt, delay in forwarding the FIR is fatal, but it is not by itself fatal. It will be fatal when, if at all there is a question as against 3 persons, the person who lodged the complaint, the person who had received the information and registered the FIR, and the person who had registered and investigated the case. Why the cross-examination is necessary on the point of delay, not only regarding the travel of FIR, but travel of all the documents to the court, because the delay of unexplained and undue delay alone is fatal. How can we say there is no, it is an unexplained delay? If you put a question, there will be a chance to the investigating officer to explain why there is a delay. So unexplained and undue delay alone is fatal to the prosecution. Very recently, the Honorable Supreme Court rejected the case of delay of 1 year in preferring the FIR. It's a case of murder by poisoning. But on that point, Honorable Supreme Court rejected, but extended the benefit of doubt and acquitted. 2024 SEC criminal. The the necessarily there must be a cross-examination according to the Honorable Supreme Court, AIR 2008 Supreme Court, AIR 2008 Supreme Court, page 92. So we have to go through the original FIR. If we look at the original FIR, we may find out in some cases there may be some corrections by using white pen. If we are able to find out some corrections in time of reporting or any other name of the accused or place of occurrence are highlighted by using white pen and the corrections are there, we can point out the person who registered the FIR regarding there are some corrections. If there are some corrections are there, it is a point to reject the FIR. And Division Bench of Honorable Madras High Court in many judgment rejected. One of the judgment is Murali Swami alias Muralidharan. Murali Swami alias Muralidharan versus State of Tamil Nadu. It is a reported judgment. Division Bench has decided this. 2007 MLJ Criminal 796. 2007 MLJ Criminal, page number 796. And 2007 MLJ Criminal, volume 2, page number 153. Sendil Kumar versus State. 2007 MLJ Criminal, volume 2, page number 153. In Sendil Kumar case, name of the accused, place of occurrence, time of occurrence are all altered. So the Honorable Madurai Bench of Madras High Court rejected the prosecution on the ground. There are many corrections, and so the evidence of PW1 is unbelievable, untrustworthy, and defective investigation. So the benefit of doubt was extended. In a triple murder case, very, very famous case, Ayyadurai versus State. Ayyadurai versus State, reported in 2008, volume 3 MLJ Criminal. 2008, volume 3 MLJ Criminal, page 257. The judgment was authored by His Lordship Honorable Mr. Justice S. Nagamuthu. He started the judgment as barbaric attitude and act of the accused. It was begin with such a case of a triple murder. The manner of registration of the FIR, case diary, and perfunctory investigation was taken note of. And since there was a delay in FIR and there are corrections in the FIR, though it is a case of triple murder, the Honorable High Court has held for lack of legal evidence and noted the delay in FIR, the benefit of doubt was given to the accused. So we have to take care in putting cross-examination with the person who lodged the first information and who prepared the first information report, as well who investigated the case. In a peculiar case, if we look at the original complaint, we can find out something. There will be some point which cannot be school of law. By the Honorable Supreme Court from Kerala High Court. Cramped handwriting. Rajivan and another versus State of Kerala, reported in 2003, volume 2 crimes. 2003, volume 2 crimes, page number 260. Trial lawyer may have an idea. If the injured person is taken to the hospital, police may get signature from the person. He may not be in a position to say. towards the end portion, just above the signature, though there was adequate space in the next page. So the Honorable Supreme Court came down, it has been held that signature was obtained in the blank sheet. Details were written.
Unmute. Unmute yourself, Mr. Karunanithi.
Yes, sir. Sorry, sir. Some network problem.
No
So,
issues.
due to cramped handwriting, it was brought on record by the learned counsel before the trial court. So the Honorable Supreme Court had an opportunity and recorded and extended the benefit of it. In yet another judgment, the Honorable Division Bench of Madras High Court, in a double murder case, appreciated the evidence, appreciated the cross-examination in a double murder case. It is a Krishnamurthy and another versus State of Tamil Nadu. Krishnamurthy and another versus State of Tamil Nadu. The Honorable Court recorded, in spite of specific questions being asked on such a lapses, IO has failed to offer any explanation, and so conviction was recorded. So in some of the cases, the cross-examination made by the learned counsel who appeared before the learned trial court was appreciated. In many cases, the lack of cross-examination was highlighted by the Honorable Supreme Court and the Honorable High Court. The appreciation of evidence can be done by the trial court, and evidence can be reappreciated by the appellate court. In order to appreciate the evidence, both oral and documentary, we have to be cross-examine the witnesses so carefully. If FIR is neatly written, within a very short span of time, then it is also a fatal. In Datar Singh versus State of Punjab, reported in AIR 1974 Supreme Court, page number 1193. Within 1 hour, it was reported, crime was reported, but neatly written with a very good write-up. So it was doubted, coupled with the fact that there is a delay in forwarding the FIR also. So it was doubted, benefit of doubt was extended. We have to concentrate more on the FIR. If if accused is well known to the first informant, if his name is not fine placed in the FIR, if there are corrections, if the signature is obtained and very narrow write-up, if very neat, clean FIR. So the proof of a case, the prosecution is heavily burdened. If contradictions are there, we can say there are many contradictions and the evidence of the prosecution witnesses has to be rejected. If prosecution has adduced cogent evidence, a witness without any contradiction deposed, Even then, I used to say the evidence of a particular witness cannot be accepted because the evidence is like parrot. So parrot-like evidence cannot be accepted. He was tutored. So also the prosecution evidence has to be rejected. If the contradictions are minor, it guarantees the truth. According to the Honorable Supreme Court, such evidence, if minor contradictions are there, such a witness is a honest witness. According to the Honorable Supreme Court, minor contradictions are there. Sogarup versus State of Madhya Pradesh. In Sogarup versus State of Madhya Pradesh, 1972, Volume 3, SEC, page number 751. 1972, Volume 3, SEC 751. If minor contradictions are there, then it has no bearing, and those witnesses are safe witnesses, honest witnesses. So we can rely on and safely convict. So this is yet another point. We used to attack the evidence of a particular witness. They are related to the victim or PW1. Whether the related witness evidence is liable to be rejected or not. No, it has to be weighed more. We have to approach such a related witness with great care and caution, but still we have to elicit such and such witnesses are related witness. Their evidence are liable to be rejected. For placing all points before the trial court and before the Honorable Supreme Court or the higher judiciary, we have to elicit on record. Why? Because the case of the prosecution is in the form of a final report. The case of the prosecution is very much available in the form of a charges. Then if learned judge is putting a question, Mr. Counsel, what is your defense? How the court can come to a conclusion, what is the defense? It can be seen, a defense can be seen only from the cross-examination, to my knowledge, in all cases, in all criminal cases, the first information report and the genuineness of FIR has to be challenged. If genuineness of FIR is challenged in a case, if it is a case of murder, a test has been given by the Honorable Supreme Court. A twin test has been given by the Honorable Supreme Court in Mehraj Singh versus case. In Mehraj Singh case, what is that twin test? Whether FIR is forwarded to the medical officer who has conducted the autopsy, whether there is a delay in forwarding the FIR or not. To bring it on record, we have to put cross-examination to the investigation officer. Sir, have you forwarded the first information report to the doctor who conducted the autopsy, along with the requisition to conduct the postmortem? Have you annexed the requisition to conduct the postmortem as a document in the final report? Whether this has been very much pleaded in the document. And the delay in forwarding the FIR. If no such a document, that is, if FIR has not been forwarded to the medical officer who was expected to conduct autopsy, then according to the Honorable Supreme Court, the first information report was not ready on the date and time as claimed by the prosecution, and the approach is, the FIR is doubtful. And placing reliance on Mehraj Singh case, the Honorable Madurai Bench of Madras High Court acquitted an accused in a case of murder. It's a reported judgment, Mahadevan and others versus state. The judgment in the year 2012, reported in the CDJ 2012. CDJ 2012, MHC, page number 3953. And yet another test is also by the Honorable Supreme Court in Gauri Shankar versus State of Karnataka, 2009 Criminal Law Journal, page 304. 2009 Criminal Law Journal, page number 3042, Gauri Shankar versus State of Karnataka. If contradictions are there, we have to elicit there are some contradictions. We have to bring it to the knowledge of the IO, whether such and such witnesses has stated in your statement in such person. So we have to contradict. Very recently, the Honorable Supreme Court, as I already stated, came down heavily and recorded that the Learned Trial Counsel did not know how to contradict a witness. If in some cases, if we place reliance on a particular book authored by a particular medical expert, then we have a duty, we have to bring it to the knowledge of the person who deposed before the trial court. Suppose a postmortem doctor opined in particular way, if we are differed in such a way, we have to bring it to the knowledge of the particular doctor that so-and-so doctor authored this book. As he is also an expert, you are also an expert. He stated in his book, page number so-and-so, how you are differing with the opinion authored by so-and-so famous doctor. Unless otherwise, we cannot cite simply the book authored by some medical expert. So we have to take pain. We have to take pain before cross-examining. We have to consult a doctor in case of injuries, in case of assault, in case of a murder. We have to go through all the documents. And insofar as a minor contradiction and minor loopholes, 2023, Volume 1 SEC Criminal, page number 192. 2023, Volume 1 SEC Criminal, page 192, Pappu versus State of Uttar Pradesh. Pappu versus State of Uttar Pradesh. The Honorable Supreme Court recorded that the loopholes and very small investigation lapses do not vitiate and the fundamental can be accepted. That is why the conviction was confirmed by the Honorable Supreme Court. And in some cases, some of the witnesses used to say the exact version as find place in the final report or in the charges. It is nothing but dramatic evidence. If a particular witness comes to the witness box, deposed that A1 assaulted in the neck, A2 assaulted in the right side of head, that is in the parietal region, and 3 assaulted in such and such places. If more than several accused are there, and for each and every accused, overtalk is very clearly given by the witness, then we can say how long the occurrence took place. We can say the occurrence took place within very few minutes. Definitely this question must be there. Then we can rely upon a judgment of the Honorable Supreme Court, reported in 1981 Criminal Law Journal, page number 736, very famous case. Selvi versus State of Tamil Nadu. Selvi versus State of Tamil Nadu. Dramatic evidence. If a witness is giving very minute particulars, his evidence is nothing but dramatic account. No one can reproduce his statement before IO, that too in a dramatic manner. This evidence is like parrot. So the evidence of PW1, who was a solitary witness, was rejected by the Honorable Supreme Court. And we have to concentrate on diary, police diary. There are, my learned brothers and sisters knows well, there are 2 diaries. One is case diary and another is general diary. If we are assaulting and taking a plea that earliest information was there and that was suppressed, that was replaced, earlier FIR was replaced by the FIR marked in the case on, then we have to send for the diary, general diary of the police station. there are many judgments in 2023 also and 2024 also. My Lord Honorable Mr. Justice M.M. Sundaresh, the judge of the Honorable Supreme Court, placing reliance on the cross-examination and the general diary, extended the benefit of doubt and the earliest judgment, State versus H. Srinivas, State versus H. Srinivas, 2008, Volume 3, SEC Criminal, 2018, Volume 3, SEC Criminal, page number 267. 2018, Volume 3, SEC Criminal, page number 267. And in P. Kalaichelvan versus State, P. Kalaichelvan versus State, 2019, Volume 2, Law Weekly Criminal, page 161. P. Kalaichelvan versus State, 2019, Volume 2, Law Weekly Criminal, page 161. After the first information report, in many cases, the prosecution used to rely upon the confession of an accused and the disclosure statement. We have to challenge the confession of the accused before the police officer as well the disclosure statement. In cases based on a circumstantial evidence, definitely the prosecution will come with a theory of extrajudicial confession. Extrajudicial confession. In such a cases, we have to put questions to the person who lodged FIR. In many of the cases, IO used to take the custody of the accused even before FIR or even before the date and time of alleged confession and disclosure statement. So, if we are able to elicit that before the alleged extrajudicial confession or alleged confession before the police officer, that the accused was seen by the witnesses in the police station or in the custody of the police officer, then the credibility of those documents can be rejected. Those documents will necessarily be rejected by the learned trial judge. So we can attack the prosecution case on the ground there are material contradiction. There are some corrections. Many witnesses have seen the occurrence. Prosecution has omitted to bring the witnesses, independent witnesses, to say all these points, to argue the same. We have to elicit from the mouth of the investigating officer, right from the FIR and statements regarding the omission in the 161 statement, omission in the FIR has to be brought to the notice of the witnesses. Then only we can get success in the prosecution case. So before concluding, I want to repeat that we have to take more care. We have to take more care in cross-examining the witnesses. We have to prepare in writing before cross-examining the eyewitness in case of that to a murder case or defending a POSCO cases or any other cases in which presumptions are there. During the course of trial and during the course of the trial, there may be some pressure on the learned counsel. So due to pressure or other reason, there are possibility to omit questions. So I humbly request, we have to get a note, and by reading the notes, we have to cross-examine, we have to take all the plea, we have to prepare a defense before making our I have completed some points regarding the cross-examination, and in so far as the confessions are concerned, whether some other persons are there to pressure the accused, we have to elicit, and whether there was some influence or pressure by the police. We have to go through several judgments. We have to keep in mind how the confession can be rejected by the court. For appreciation of evidence, we have to argue not on air, but pointing the cross-examination. We have to read the cross-examination elicited by us. That is why I am once again pointing that cross-examination is an acid test. It is a very, very tough job, very, very important job. And once again, I want to read the judgment of the Honorable Madras High Court. In Muthu Pandi case, para number 32 to 34, I will read and then I will conclude. Paragraph 32. With great thanks to the Honorable Judge who rendered the judgment, we are grateful to the Honorable Judge. At this juncture, this court has to necessarily record its displeasure in the manner in which the witnesses are cross-examined on a daily basis. This court is able to find that the standard of cross-examination of witnesses has gone down drastically. It is quite unfortunate that the trial court advocates are not developing their skills of cross-examination. Most of the questions which are put to the witnesses are irrelevant and illogical. For instance, when PW6 was cross-examined in this case, a question was put to her and was asked to explain as to whether hymen will get ruptured due to insect bite. This would show the amount of ignorance on the part of the counsel on human anatomy and medical jurisprudence. This is the only a sample, and many such illogical questions are being noticed by this court on a daily basis. The trial court advocates must bear in mind that they are defending the right of a person guaranteed under Article 21 of the Constitution of India. Hence, it is their bounden duty to put appropriate questions during the cross-examination, failing which their client will lose his or her liberty by suffering a sentence. The art of cross-examination was considered as a crown in the advocacy skills. If this art is lost, the charm in conducting a trial before a court will also be lost. So we have to keep in mind the judgment of the Honorable Madras High Court and many judgment of the Honorable Supreme Court of India. Keeping in mind these judgments, we have to improve our skills in establishing the case of the defense before the learned trial court. Unless otherwise, the learned trial court advocates have elicited something in order to reject the evidence of a particular witnesses. We cannot argue on the air before the Honorable Higher Judiciary. Hence, my humble submission request is we have to take more care before preparing for cross-examination. If it is a case of murder by poisoning, if it is a case of murder by burn injuries, there will be a postmortem certificate, and we have to go through the bed ticket, namely the case sheet maintained by the doctor. If case of 307 is registered, and after many days, if the victim suffered with death, then we have to go through we have to summon the by invoking 91 CRPC, we have to summon the original record. In many cases, investigating officer will not collect the bed ticket or the hospital records of the injured while filing the final report. But it is our duty, whether there was proper medical treatment or septicemia is there, whether death is due to septicemia, we have to go through the medical records of the victim. If it is a case of murder by burn injuries. There will be a first degree injuries, second degree burn injuries, and third degree burn injuries. We go to see what was a medicine which was administered. If it is a case of first degree burn injuries, the pain will be more. If it is a second degree burn injury, pain will also be more. So the pethidine like injection will be administered. Then the central nervous system will be in some time in some kind. There may not be in a conscious possession. The time and date and time of recording the dying declaration, as well the administration of the administering the date and time of administering the medicine will have to take a note of us. Then only we can project our case so properly. In a case where I defended before the Honorable Madras High Court, there was a case when PW1 came to the witness box, deposed that there was a cry. So myself and my uncle went to the ground floor. One accused assaulted the aged person living in the ground floor. Immediately, my uncle went there. My uncle was also attacked by a person nearby the place of occurrence. So one person sustained injuries and one person died, witnessed by two persons, one injured witness and yet another person. So they have given evidence. They have not implicated A1 and A2. So the cross-examination was deferred. Cross-examination was deferred by the learned counsel. After a week, cross-examination was made. According to the first question, the accused are not known to you. They are stranger to your place. How do you know? How you are identifying these two accused? PW1 and PW2 deposed. They are working in the ground floor for a month. So we are able to identify. This was not, the accused was not identified during chief examination. So another question was there. Who assaulted the lady? Who assaulted PW1? So PW1 and 2 clearly stated the person wearing white color t-shirt assaulted the lady. The person wearing red color shirt assaulted my uncle. There ends the matter. Conviction was recorded. When a learned counsel argued before the principal seat of Madras High Court, the division bench headed by Honorable Mr. Justice S. Nagamuthu posed a question, sir, whether cross-examination is also evidence. You used to argue chief examination as well cross-examination is the evidence. Yes, sir, no doubt it is evidence. Then read the cross-examination made by your friend of PW1 and 2. There ends the matter. You take your seat. You have filled up the prosecution. Though the prosecutor did not elicited from PW1 and 2, you have elicited. The case was ended in conviction. So we have to take more care when we will put a cross-examination. If some witnesses, some persons coming to us, they are appreciating us, can we oppose it? When a witness, when cross-examination will come into play? Why we are cross-examination? We have to cross-examine a particular witness. If at all the witness is pointing towards the guilt of the accused, there will be no point to cross-examining the particular witnesses. So we have to take more care before cross-examination. We have to prepare well. So with this, I conclude. Jai Hind. Namaste. Thank you, sir. the A. Muthupandi versus State by Public Prosecutor High Court Madras was decided by judgment dated 3/4/2023 by the Principal Seat of Madras High Court by Honorable Mr. Justice N. Anand Venkatesh. You can find it from the website as well in the Indian Canon. Thank you, sir.
Thank you, sir. And we are already receiving lots of messages on the chat where they're appreciating your knowledge sharing process. Everyone stay blessed and stay safe. And tomorrow we will connect at 6 p.m. Do join us on our WhatsApp groups for latest updates as well as subscribe to the channel of Pure Law CLC. Thank you. Namaskar.
Thank you.